Good morning, friends. Sat Sri Akal, Adab, Namaskar. This is in continuation to my historical videos, and this is the 182nd video. And this is going to be a very lengthy video because this is a very peculiar cantonment named Secunderabad. I've been in touch with lot many people, and I'm very grateful to our ex-DG, Mr. Srinivasan, through him and some DOs posted in Secunderabad, along with the bungalow owner, Mr. Reddy, who actually shared a lot of documents and evidences with me and some reports made during this period from 1806 when the cantonment first came in existence. You will be surprised, this cantonment, which falls under Madras Presidency, was and is one of the biggest cantonments during that period. It covered an area of more than 10,121 acres. And at that very period only, it was written that 3,000 acres of land was private land in this cantonment. And there was approximately 236 acres of civil area. After Googling, after trying to research into various gazetteers, which I had been holding on since 2009 when I visited the archives office. So I came across a report made by Sir William Bartons. And this report was somewhere made in 1925 onward, where he clearly admits that this is one of the biggest cantonment, holding an area in radius of about in diameter approximately about 16 square miles, consisting of 13 villages which were later named Moghlai villages way back in 1806. He admits that there were never payments made for acquiring these lands. These villages which I just named were called Moghlai. During the the British Raj, the only sovereignty which transferred to them was of this policing and sanitation in this part of the cantonment. The civil, judicial, revenue collection and journal administration of Secunderabad cantonment remained with the Nizam government. So what was happening? What was the original agreement between the Nizam and the Britishers then in 1806 is to be studied. So the Britishers were only holding areas which were in active occupation of the military authorities, and they enjoyed full rights in that area of civil and criminal jurisdiction. But the most interesting part even then was that of that very area of which the military authority was holding, the revenue or the collection or the charging of revenue remained with the Nizam government. So that authority was never transferred. Now, Secunderabad, unfortunately, there was never a record of rights made. So there is no register of properties in Secunderabad, either from 1806 or even later on. An attempt was made as per this report in 1871, but it was an uphill task, so it was basically abandoned. So there he mentions a letter of 15th June 1899, where he clearly assigns that Secunderabad was under a foreign territory. So the foreign secretary observes that no land has been assigned to the government of India, that is the British, by the Nizam government for military purpose. Occupation has been acquiesced in because the British government wanted it for military purpose. The purpose was simple, of cantonning their troops. So this scathing statement which Mr. William Bartons is stating is something that he says that we British must be careful in notifying the residents whenever any land, including in the military purpose, as an unqualified statement to this effect would possibly justify the Nizam government in asking that in land in question be given up to them. We must not make use of any language making a distinction between the two. So it's a clear observation given by him. A letter number 5 of 6 January 1896, written by Sir Chicholi Palodon, he speaks, there is therefore no land in Secunderabad which absolutely belongs to Government of India and military authority. They are entitled to exercise control only over so much of the land within the boundary pillars and has been actually assigned to military authorities by the Nizam government. For example, the administration and the revenue paying on these lands was within the officials of the Nizam government, and they were the ones who had to collect revenue from these lands. So the first survey map made in 1884 by Major Stiveron, assisted by a Nizam government official, Secunderabad cantonment is scattered. It is not a chunk of land or a composite piece. So there were 3 types of lands. The military area, which includes all the land actually assigned for military purpose. 1. 2 is that Moghlai villages, which rose to number 18 now in this report from 13. The civil area, which comprises of all the land's external boundary, not including in any other area. So was this civil area not a part of the Moghlai villages? Or was it a part of the military authority but was a civil area? Certain rules and enactments were made to occupy lands within military area. 6th May 1873. So grant applications were made and approved by the hierarchy of officers. So it was not very easy to get a grant in Secunderabad. Most of the civil area or land is private property, and the sovereign rights vest with the Nizam. The Britishers or the British government would enjoy the same right in residency bazaar as that of civil area, and in Nizam in complete sovereign. So even the residency bazaar, which was under the military authorities, the sovereignty remained with the Nizam. So the visibility of sovereignty here is of no question. Government of India acknowledged the same by letter 20th June 1808. This was a letter number 1753 IB, not to interfere in the matter of land in Secunderabad. This report speaks of how lands are generally taken over by the military authority, which is in turn British India, but things were different in this Nizam territory, and cantonment laws were only made applicable likewise. So there was a notification for all this. Various letters, surveys came up. This report is huge. It speaks of 1909, both the Secunderabad and Bolaram, the land was actually owned by Nizam government, and from time to time it was handed over to the military authorities. Let's say they wanted more land. Any individual now, whether it was a British officer, whether it was a native Indian, was willing to purchase or lease a bungalow, had to take permission from the resident of Nizam government alone. So the British authority had no power to grant or lease these bungalows. So cantonment or military authority was not allowed. Plan of Secunderabad was never corrected as per the Nizam's order of 2nd October 1909. Friends, I would again request anybody watching this video in Secunderabad, please dig into these references and documents which I am talking of. The cadastral survey which was carried out and finally incorporated in Hyderabad contingent two villages named Kovkur and Mahadevpur were included in the cantonment in 1909. Now, why were they included? They were only included for sanitation purposes. So, another 2,059 acres of land was handed over to the military authorities in 1916. And out of this, half of the area was Sarfe Khas. Now, what does this Sarfe Khas means? I leave this part to the acumen of the Secunderabad people. Let's see how much they can dig into the word Sarfe Khas. Now, the Britishers in 1899 had brought in a House Accommodation Act bill. So, whether this act finally could be implemented in Secunderabad, there is a letter dated 20th March 1899, which clearly clears the same position of landholding within Secunderabad. So, he clearly states that grants are under special rules framed under the 1873 order. So, the House Accommodation Act applicability would become difficult. Well, we need to understand this important distinction between a cantonment, which is within the British India, and the cantonment which is in Secunderabad. What is the difference in the lands? The British cantonments or the Indian states where land was definitely assigned for the purpose of cantonments. But here in Secunderabad, the lands were never assigned to the making of cantonment but were given to military authorities, and they were never acquired. So, these are very clear points. But here in Secunderabad, there is no proof of assignment of land where it says that it was only handed over to the military authorities free of charge by the Nizam government from their occupation. The land was given for making barracks, officers' bungalows, military buildings, and rest all the lands which included in the boundary pillars of the Secunderabad, the sanitation and police jurisdictions lied with the military authorities. Now, it speaks of a very important point. It says any such land would revert or relinquishment, if so called, in the civil area, such that land not actually occupied by military authority would but required for subsidiary purpose of cantonment administration. Now, any change in the uses of land, the land reverts back to the Nizam government. Such site may have been given for military bungalows, but it cannot be given for shops, houses or private individuals. So, would we call this entire Secunderabad as A1 land in the 1925 classification of land? Now, if a bungalow is, or a private man or individual or a military officer is wanting to acquire that bungalow, the correct procedure will be to inform the Nizam government and ask to prepare a sale agreement or sell it to him, or he could have even leased it to him. In the civil area outside the military area, properly so called the 18 Moghlai villages, the control of the cantonment authority was only to building bylaws, nothing else. Sanitation and policing was already there, but even if these villages were concerned, so the police had to give up to the charge, the policy of land in this Nizam government was that after charging ground rent, which in turn would be called land revenue and would be paid back to the Nizam government. But when it comes to military authority, this entire land was given free of ground rent. So friends, please understand, I have a bungalow owner I am unable to name him and his president. They dispute this topic of mine a number of times and hours on the mobile. That Mr. Das, that no land in Secunderabad is paying land revenue, where the Nizam very clearly said that any land which is outside the military authority but within the cantonment boundaries will be paying ground rent. The land with military authority was given to them free of this ground rent. So, this dispute would settle here in cases where no land revenue was being paid. Land owned privately with the consent of the Nizam government would not be necessary. In the town of Secunderabad, apparently land is being held by privately arrangements. The position was thus clear in Secunderabad that British government in regard to lands could not grant any land but could ordinarily frame rules for their sanitation and policing alone. So now there were wastelands, there were agriculture lands in this entire 10,000 and some acres which was taken up. So was it that the Britishers were acquiring these wastelands and agriculture lands under the British India domain and for building purpose, not connected with the cantonment administration? No, but in Secunderabad. Now he says the same is held by state government and for only administration purpose it was rendered with the British government. Nizam's letter number 276 dated 8 February 1904 clearly reads that it will be provided free of cost to military authorities for the making of cantonments. Such land will be included in delimited areas. Nizam government will or be very insistent on their right to resume possession when any land is delimited by the military authority by saying it is no longer required. So here the control of building by a British government letter 1st December 1904, including for 13 or 18 Moghlai villages, was given to the British government or the military authorities, and they were mere licenses and the subject of decision as per the title of land is occupied. So here again the word license is being used for even those civil areas or the 13 plus 5 Moghlai villages. So friends, we have to understand when this entire report was being made in 1925, what actually was going through William Barrington. So once we understand this, we'll be in a better position to understand how things were working. Now coming to some historical facts, in 1947, to expand the Begumpet aerodrome, the then government wanted to resume some 7 bungalows, and you will be most shocked that these bungalows were issued resumption notices under Land Acquisition Act, and then these bungalow owners had gone to the court. And what is now the status? Now bungalow number 165, Mr. S. Madhav Rao, bungalow number 164, Feroz Nadir Shah Chinoy, bungalow number 167, Mr. Bhairamji Darabjung Chinoy, 171, Mr. Idulji Palonji Chinoy, 161, Irhoy J. Chinoy, 166, H. S. Chinoy, 163, F. S. Chinoy. So the MEO very clearly writes that we need to abide to the lower court orders and we'll have to pay them compensation under the Land Acquisition Act along for the land. Now what is the judge has not accepted our contention? This is what the MEO is writing, a brief to the ministry, that lands were formally granted to the predecessors in trust. of the formerly the claimants free of cost for building purpose, that they were not the owners or the pattedars of the land, but were only permissive occupier, and therefore they were not entitled to any compensation for the value of the lands resumed according to the conditions of the criminal grants. Now this the judge is not agreeing. On the other hand, the judge is held that the lands were private. Properties situated in Nawab Salar Jung Jagir village of the Kota, and the government have not proved that before the sum were made over the Nizams government to the British military authority or the military authority, and acquired the lands from the then owners by payment of compensation, and the lands continued to be private properties of the claimants, and so they were entitled to compensation of lands. The court has awarded this compensation. An interest rate also has been given by 12 annas per square yard, approximately making it about 5 rupees per year, claimed by several parties, and so on. The idea goes up till about 7,000 rupees or approximately 6,000 rupees per acre. The court has rejected the claim of Rashid Sanpurji Chinoy in the case number 1952 for enhanced compensation of land in Begumpet village, which was acquired for the. Never mind. Another bungalow owner, it says now, bungalow number 179 of Bolanpalli, Secunderabad, survey number 525. It dig into the records of it. These are reports being made. A sale deed of 27th June 1927 and his suit number 38 of 1925, wherein he has annexed some Appendix A, Appendix B and Appendix G and H. These are revenue record receipts of this land. This includes all the documents if we people can dig into this suit. These revenue receipts will help people in the entire 18 villages. With these facts, the MU is very clearly saying that it is admitting that this bungalow is a private bungalow. So the GLR, which was first prepared in 1933 for Secunderabad by Captain James, then as a special land officer for Secunderabad Cantonment, is absolutely wrong. Another letter, correspondence between the department and the MU, bungalow number 218 situated at Gymkhana Road. When these inquiries were made, this was basically given for residential purpose and was a non-agriculture property as per the revenue register. So what is everything reflecting? That Secunderabad, all revenue records are available. So for bungalow owners or for residents of these 13 villages, you can always dig into all your records, and these letters are there in my records. We can share them out, and there is nobody in Secunderabad who will not be paid compensation under the Land Acquisition Act then or the Land LARR of 2013. So these statements, are very important. MU is even asking for the rectification of the GLR land records of the village Takota. So he clearly says, an extract of Hyderabad residency, the same one which I just read above, of 1906. So bungalow number 206 is also termed to be a private property. Now where is it? Simply dig into this record. A Ministry of Defence letter dated 28th April 1986 speaks of this. Now finally the department goes to an attorney general and seeks a legal opinion. So he very clearly writes those similar things, which if you want I would read for you. Even otherwise, there seems to be a total difference in the origin of Secunderabad Cantonment from the other British cantonments. When the East India Company is divided into 3 British armies, called the Bengal Army, the Bombay Army and the Madras Army, each having separate regulations. Governor General Order of 1836 was of Bengal Army and was not automatically applicable on Madras Presidency. So this point clears that GGO 179 is not applicable in Madras. Secunderabad cantonment, he says, was governed by the Madras Army regulations of number 1284. Where is it written? It is written in the Military Land Manual. The Secunderabad area belonged to the Nizam, and out of this, the Nizam carved out this area or to the army. He carved some villages as such as cantonment area and only gave them a, I would call, a restrictive sovereignty, where the judicial and policing and general administration, including revenue and judicial, the status was with the Nizam. In the cantonment authority only had sanitation and building bylaws. So it is very clearly in this case of Secunderabad and what the Britishers have admitted in the Imperial Gazetteer, that sovereignty was divisible when they were ruling India, after the Diwani which shifted to them in 1765. So the Britishers were never the complete sovereigns. When did they become the complete sovereign is a matter of evidence and question which needs to be answered. So the whole document of Nizam 906 is again read. The full and complete criminal and police jurisdiction of 13 Jagir villages, refer to margins or grants on behalf of His Highness Nizam government. So this keeps going on. Now he talks of 1952, when some land in area of cantonment was acquired. He is mentioning those same bungalows which I just mentioned above. Now he says the matter was taken up in the court, where the court number 19 of 1952 and court proceedings of number 39 of 1952, court proceedings 43 of 1952, court proceeding number 45 of 1952, court number 63 of 1952, court number 64 of 1952, court number 65 of 1952, all judgments combined and given on 1st November 1961, the Chief Judge, City Civil Court, Hyderabad, at Secunderabad, went into the tenure of Secunderabad cantonment, and a detailed order is there. When the question is whether any person is owner of anything of which he is shown to be in possession, the burden of proving that he is not the owner in possession or on person who affirms that he is not the owner. So the onus was on the government or the Ministry of Defence. So in both the cases, the James Register, which is one of the earliest documents made during 1904, which Mr. William Bartons had said, the 1908 notification of these two properties, original authorities' occupation is not known. So in the early 1930s, the government recognized the possession of these owners. Then there could be no presumption, or it could be a presumption of a lost grant, which is not forthcoming or is available. And this is a lawful proposition which can be made by the owner in occupation of this bungalow in origin. So we were given by this legal opinion a right that we can even ask for that, are we a lost grant? So this claim becomes very important. It is true when the owner is unable to bring in records, and who is the owner and the custodian of records needs to be understood. So lands in cantonment should be deemed to be held under old grant by just changing the entry, or this uses of word old grant itself has no meaning, and it does not have universal meaning to have the ownership of government without regard to the context of the origin of the cantonment in each case. The origin of Secunderabad cantonment is different from other cantonments. Most mere use of old grant used with reference to the expression being used in other state has no significance in Secunderabad. So this opinion of the officer is very important, and it can be taken to other cantonments. What really is the definition of old grant? Even generally, the origin of the cantonments, when the ruler has given the territory for occupation of purely military purpose. So these two situations of a cantonment arises. One situation may be in which a tract of unoccupied wasteland is given with transfer of ownership with sovereignty to territory being retained with the ruler. Now that's very funny. In most of the cantonment it is something like this. The second is allotment of land without transfer of ownership sovereignty of the area being retained by the ruler. In the earlier one he says wasteland is given, in this one he says territory is given but no ownership is given. He even creates a third situation where existing villages occupied by persons already. So these are those laldoras or the Abadi area already with residencies have been allotted, where the wastelands are used for construction of buildings for military purpose. So friends, please relate this third part which the legal opinion attorney general is saying. The document of title of bungalow, which ranges from 1868, 5th December, prior to 1906. He takes of the document of 1910, 1912, 1926, 1936 and 1967. All these documents have been treated of absolute private property and in possession of the owner. So this is where I keep telling people, please dig in your land records. So the advocate talks here of admission deeds now. The Attorney General, the government seems to be relying on an affidavit which came after 1937 CLA rules of 2nd October 1945, allegedly to be have taken by Shri Sayyid Shah Abdul Sahib Kumzul Kardari. No such affidavit is available on record of Shri Kardari himself had executed a gift of the bungalow to his 3 daughters as absolute owner of the bungalow with all lands in question, of his admitting government proprietary rights in the land does not arise. So admission deeds taken prior to the owner will become important, and then only can you counter yourself. Moreover, it has been repeatedly held that admission itself does not transfer or title. Admission is not a conclusive proof under section 30 of the Evidence Act. Various judgments are there which can be worked out. 1868 document itself mentioned that there are title deeds to the property. Now 1868, when did the first registration act came? 1877. When did the sub-registrar powers came to the cantonment magistrate? 1864. So 1868, it is the cantonment magistrate who is making title deeds of these bungalows or these lands in this 18 or 13 Moghlai villages as well as Secunderabad. What is being handed over till 1868 document is land along with building. So the government needs to produce its possession or its ownership, and without this it is very difficult, he says. So this is a simple case of lost grant, and can we actually take it to that level is a question mark. So we need to understand, friends, how Secunderabad was developing and how things were moving in Secunderabad. Cantonments are everywhere. So Secunderabad had a very different proposition, being in Madras Presidency. There are another 4 cantonments in Madras Presidency, but they are under the Mysore tenure. So we have to work out to all this. Only then can we work and say what are we actually doing. I have just tried to make people understand this, which I'll continue in this video only. What I am trying to tell everybody is that we have to just see what are we actually looking for, what are we actually doing. Are we really doing something? Are we really making something? As far as Secunderabad cantonment is concerned, it may be mentioned again that there is an n number of happenings in the 18th century treaties, which cover a long period of several treaties between the East India companies and the Nizam of Hyderabad. The Treaty of 1766 can easily be dug out. It is in the archives library. We have the Treaty of 1768, then we have 1790, then another treaty was made in 1798. It is only the encampment of the forces of East India Company near Hussain Sagar tank after the fall of Tipu Sultan that the troops of East India Company seems to have settled in this area in 1806, wherein the barracks were occupied and the column of land ownership was named under the cantonment but by the name of Nawab Sikandar. It is this cantonment which can be said to be in the origin of Secunderabad cantonment. The cantonments of Bolaram and Aurangabad further merged with the British forces in around 1903 in Secunderabad. So now it is very important. Here he talks of Aurangabad also. The land tenure in Secunderabad was never entirely vested in the cantonment lands, and in fact were divided on the basis of title having different sources of entitlement. The position seems to be clear in that actual area, only being under military occupation was treated as cantonment area. The classification of these land tenures indicates that there was five-folded kinds being state lands, Pahag lands, Saraf-e-Khas lands, Inam and Jagir lands, and Patta lands. So these were the five lands which were there in the Nizam's territory. Now friend, I have been always saying that what was the actual occupation of the military authorities then when your first cantonment came up is very important. So the source of holding Patta lands was with the respective authorities who settled the lands with private individuals in perpetuity for the purpose of cultivation and subject to a land revenue. By legislative enactments such as Hyderabad abolition of Jagir regulations and Sarf-e-Khas merger regulations made applicable during the period of 1948-49. The Jagirs and the Sarf-e-Khas were abolished. I asked for people to dig into the Sarf-e-Khas judgments or the definition. There is other factual data which shows that old grant entries consisting the remark classification of B3 is presumption and has no legal basis. Such arbitrary entries do not clothe the government with any right or title to the property. It is noticed that similar entries in GLR concerning bungalows lying within the areas have been eventually corrected with regards to bungalow number 43, 16B, 170, 206. These corrections are a part of records of the Ministry of Defence. Similarly, when lands were required are a part of Moghlai villages, was sought to be acquired, the matter concerning compensation under Land Acquisition Act was taken up in civil courts. So I have already told you about the Begumpet aerodrome when was being, so that order of 1st November 1971. Please friends, dig into these order details. Some people get together and then your complaint or your pleadings will come. So no bungalow owner or no civil area or resident of these 18 villages will have a problem. So further, a joint survey taken in February 1986 in the presence of Deputy Director Land Records Hyderabad and Defence Authorities, wherein it was found that survey number 82 was part of Bovenpuli village, while survey number 133 was part of the Kotha village. Survey number 12 and 13 were a part of Sitampur village. All these villages were a part of Moghlai villages, which were holding private rights, thoroughly preserved. Thus, these Moghlai villages do not form a part of Department of Defence, Government of India, but are private properties. So, this legal position has been reinforced, and it was again, asked by a local advocate or a legal opinion or a counsel for Union of India. And he gave a positioning that the position has not been changed even after the coming in force of the constitution. Only because union government has come into existence, it does not follow that any property located in a particular area called cantonment would become the property of Government of India. The provision of Article 3 of the Crown Representative Transfer of Properties and Liabilities Order 1947, which was made under the Indian Independence Act of that year, has limited application to such properties which had actually vested in the Governor General in Council. The position emerging even after Independence Act should show that the Hyderabad state was constituted the areas of land in Secunderabad. Cantonment would revert back to the Nizam or the state. Now, if you see the Article 294 and 295 of the Constitution, which is concerning the devolution of properties, under the Constitution, the Union of India would get that property which had vested in Governor General in Council and no more. So, if you club these four parts and actually read them, this is proven. As per facts stated above, Government of India will have the right by devolution with regards to those properties which only vested in the Governor General in Council and not otherwise. Properties owned by Government of India even within the Secunderabad area and are therefore having different owners, it is only the property of the Government of India that could be claimed by Union Government and no other. The present concerned lands being part of the Moghlai village was exceptionally excluded in the Farman of 1906 notification. So, the pattedars were actually paying revenue land to the state Nizam in their private capacity, and there is no question of they being old grants. So, the GLR needs to be rectified. So, the owners here is very clear of these villages, do not need to worry at all. But please jumble up your evidences and records. Don't harp on that, okay, fine, my neighbor or the one who is a victim would win and then I would. There are already these 7 people who have fought these cases, dig them out. So, let's improvise on our mistakes, because now things have changed in the passage of 60-70 years. Most of the GLR under the Surinder Kumar Vakil's order of 2002 has been upheld. So, army regulations now, I will read those, which is very important, which has been confronted with this association owner in Secunderabad. 8th May 1812 clearly admits that grants had to be of a fixed size in Madras Presidency, admits there were private lands and grant was given on the same terms and conditions as per a GGO number 17-1 of 1849, where it is admitting there were private lands in Secunderabad. So, all the applications to take grant was to be routed through the Government of Nizam, which is the local board of revenue officers who will approve. Even the army regulation of 1887, not of 1873, is admitting that houses which were built on private lands whether on lease or grants, were exempted from shops or commercial activities. So the word grant is only being used, not old grant. So we residents need to understand, where are we standing in Secunderabad? Are we in a win-win situation, or do we need to dig in our records? Well, friends, I'm there. Whatever help I can do, I can always make it for you. But the question is that we need to understand our laws. We need to work. I have been insistively saying, now most of the, Secunderabad has a little separate issue than similar to Aurangabad. But the very confirmative fact is that where is this old grant defined needs to be known. And in Secunderabad, there was no grant either. And if grant had to be given, it had to be given through the Nizam government. Come back. Let's talk. Let everybody in Secunderabad, including these 13 villages, dig into these records, and it is a win-win situation. Thank you. Good day.